Searches and seizures. A search warrant is an order in writing issued in the name of the people of the Philippines, signed by a judge and directed to a peace officer, commanding him to search for personal property described therein and bring it before the court. A search warrant is not a criminal action, nor does it represent a commencement of a criminal prosecution, even if it is entitled like a criminal action. It is not a proceeding against a person, but it is solely for the discovery and to get possession of personal property. It is a special and peculiar remedy, drastic in nature, and made necessary because of public necessity. It resembles in some respect with what is commonly known as John Doe proceedings, United Laboratories versus ESIP 461 SCRA 574, citing Bevington versus United States 35 F2D 584. Also Worldwide Web Corporation versus People, GR 161106. An application for a search warrant is not a criminal action. Hence, any aggrieved party may question an order quashing the same without need for the conformity of the public prosecutor. The rule in Section 5, Rule 10 of the Rules of Court, that criminal actions shall be prosecuted under the direction and control of the public prosecutor, does not apply. The rule against unreasonable searches and seizures does not extend to acts committed by private individuals and entities. This rule is illustrated in one case in which the inspection team of an electric company conducted a routine inspection of several houses to check on illegal connections, meter tampering, seals, conduit pipes, jumpers, wiring connections, and meter installations. One of the houses inspected was that of the plaintiff, who claimed that there was nothing routine or proper at all with what the inspection team did. The team, it was alleged, entered his house and the surrounding premises without his permission and over the objections of his mates. The members of the team threatened, forced, and coerced their way into his house. The plaintiff's main argument consisted of an alleged violation by the inspection team of his constitutional right against unreasonable searches and seizures. The court did not agree with the posturings of the plaintiff and declared that the constitutional guarantee against unlawful searches and seizures is intended as a restraint against the government and its agent tasked with law enforcement. It is to be invoked only to ensure freedom from arbitrary and unreasonable exercise of state powers. Cerebrino versus Court of Appeals. The scope of protection and the constitutional provision. Like an arrest, the laws and rules governing a search warrant is based upon constitutional guarantees. The pertinent constitutional provision provides: Section 2, Article 3, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures of whatever nature, and for any purpose, shall be inviolable, and no search warrant or warrant of arrest shall issue, except upon probable cause to be determined personally by a judge, after examination under oath or affirmation of the complainant and the witnesses he may produce, particularly describing the place to be searched, or the persons or things to be seized. The right to privacy, or the right to be let alone, was institutionalized in the 1987 Constitution as a facet of the right protected by the guarantee against unreasonable searches and seizures. But the court acknowledged its existence as early as Murphy versus Mutuk 130 Phil 415, where it ruled that the right to privacy exists independently as its identification with liberty. It is in itself fully deserving of constitutional protection. Jose Jesus Decini versus Secretary of Justice, GR 203335, February 18, 2014. Relevant to any discussion of the right to privacy is the concept known as the zones of privacy. In petition for writ of habeas corpus of Camilo Sabio, Miguel versus Senator Richard Gordon, 535 Phil 687, 2006, the court said zones of privacy are recognized and protected in our laws. Within these zones, any form of intrusion is impermissible unless excused by law and in accordance with customary legal process. The meticulous regard we accord to these zones arises not only from our conviction that the right to privacy is a constitutional right and the right most valued by civilized man, but also from our adherence to the Universal Declaration of Human Rights, which mandates that no one shall be subjected to arbitrary interference with his privacy, and everyone has the right to protection against such interference or attacks. Two constitutional guarantees create these zones of privacy. A. The right against unreasonable searches and seizures, which is the basis of the right to be let alone, and B. The right to privacy of communications and correspondence, Disney versus Secretary of Justice. But the right to be let alone is not unqualified. In Warrant versus Roe, 249 U.S. 589, the U.S. Supreme Court classified privacy into two categories: decisional privacy and informational privacy. Decisional privacy involves the right to independence in making certain important decisions, while informational privacy refers to the interest in avoiding disclosure of personal matters. Informal privacy has two aspects: the right not to have private information disclosed, and the right to live freely without surveillance and intrusion. In determining entitlement to the right, the court has laid down a twofold test. The first is a subjective test, where one claiming the right must have an actual or legitimate expectation of privacy over a certain matter. The second is an objective test, where his or her expectation of privacy must be one society is prepared to accept or objectively reasonable. Disney versus Secretary of Justice. The protection guaranteed by Section 2, Article 3 is available to all persons, including aliens, whether accused of a crime or not. Artificial persons are also entitled to the guarantee, although they may be required to open their books of accounts for examination by the state in the exercise of police and taxing powers. The right is personal. It may be invoked only by the person entitled to it. Stonehill versus Diokno 20 Squad 383. As such, the right may be waived. Lopez versus Commissioner of Customs 68 Squad 320. Either expressly or impliedly. People versus Masalugi GR 44335. But the waiver must be made by the person whose right is invaded, not by one who is not duly authorized to effect such waiver. People versus Damaso GR 93516. The right applies as a DOCTRINE directed only against the government and its agencies tasked with the enforcement of the law. The protection cannot extend to acts committed by private individuals so as to bring them within the ambit of alleged unlawful intrusion by the government. People versus Andre Marti, GR 81561, 1991. This is reiterated in Waterous Drug Corporation versus NLRC, October 16, 1997, where the Supreme Court said that the Bill of Rights does not protect citizens from unreasonable searches and seizures by private individuals. In this case, petitioner's officer opened an envelope addressed to the respondent and found therein a check evidencing overprice in the purchase of medicine. The check was then deemed as admissible in evidence. In People versus Mendoza, GR numbers 109279-80, the same principle was applied relative to the memorandum receipt and mission order to carry firearms discovered by the accused appellant's father-in-law, a private citizen. In People versus Bongkarawan, GR 143944, the shabu in the baggage of the accused was found by private security officers of the inter-island passenger vessel, who then reported the matter to the Philippine Coast Guard. The search and seizure of the suitcase and contraband items were carried out without government intervention. Accordingly, the exclusionary rule may not be invoked. What constitutes a reasonable or unreasonable search and seizure in any particular case is purely a judicial question, determinable from a consideration of the circumstances involved. Belmonte versus Davila. But where the search and consequent seizure of fish allegedly caught by the use of explosives was made without a warrant, and a search warrant was obtained by the officers only much later, it was held that there was a violation of this constitutional guarantee. Manlavi versus Gacot, May 9, 1995. The Constitution mandates that a search and seizure must be carried out, true, or on the strength of a judicial warrant predicated upon the existence of probable cause. In the absence of such warrant, the search and seizure become unreasonable. Commerciante versus People, GR 205, 926, 2015. The following provision solidifies the constitutional prohibition against unreasonable searches and seizure by providing for an exclusionary rule that any evidence obtained in violation of this or the preceding section shall be inadmissible for any purpose in any proceeding. Section 3, Number 2, Article 3 of the 1987 Constitution. Also, a probable cause to arrest does not necessarily involve a probable cause to search and vice versa. Probable cause to arrest involves a different determination from probable cause to search. In order to determine probable cause to arrest, the judge, not the prosecutor, must have sufficient facts in his hands that would tend to show that a crime has been committed and that a particular person committed it. Probable cause to search requires facts to show that particular things connected with a crime are found in a specific location. An arrest with a warrant may be made on any day and at any time of the day or night. A search warrant is generally served in the daytime, unless there be direction in the warrant that it may be served at any time of the day or night. The issuance of a warrant of arrest presupposes the existence of a pending criminal case that gave rise to the warrant. A search warrant does not require the existence of a criminal case. It may be issued prior to the filing of the case. Application for a search warrant, asked in Bar 2012. As a rule, an application for a search warrant shall be filed before any court within whose territorial jurisdiction a crime was committed. There are exceptions to the above general rule. These are: the application may be made before any court within the judicial region where the crime was committed if the place of the commission of the crime is known. The application may also be filed before any court within the judicial region where the warrant shall be enforced. In both exceptions, filing in such courts require compelling reasons stated in the application. The rule requiring a statement of compelling reasons is of a mandatory nature. Filipinas Shell Petroleum Corporation versus Romers International Gases Corporation, GR 189669, February 16, 2015. The application shall be made only in the court where the criminal action is pending. If the criminal action has already been filed. Last paragraph, Section 2, Rule 126, Rules of Court. Ex parte application for a search warrant. An application for a search warrant is heard ex parte. It is neither a trial nor a part of the trial. Action in these applications must be expedited, for time is of the essence. Great reliance has to be accorded by the judge to the testimonies, under oath, of the complainant and the witnesses. Santos versus Price Gases, 538 SCRA, 474. Search warrants involving heinous crimes, asked in Bar 2012. The above rules in Section 2 of Rule 126 of the Rules of Court have been deemed modified by EM number 99-20-09 SC, dated January 25, 2000, in cases involving heinous crimes, illegal gambling, dangerous drugs, and illegal possession of firearms. Under the aforementioned issuance of the Supreme Court, The following are authorized to act on all applications for search warrants involving any of the above crimes: the executive judge and vice executive judges of regional trial courts of Manila and Quezon City filed by the Philippine National Police, the National Bureau of Investigation, the Presidential Anti-Organization Crime Task Force POAC-TF, and the Reaction Against Crime Task Force REACT-TF, with the regional trial courts of Manila and Quezon City. The application shall be personally endorsed by the heads of said agencies for the search of places to be particularly described therein, and the seizure of property or things as prescribed in the rules of court, and to issue the warrants of arrest, if justified, which may be served in places outside the territorial jurisdiction of said court. The authorized judges shall keep a special docket book listing the details of the applications and the results of the searches and seizures made pursuant to the warrant issued. In Marimla v. People, the petitioners filed a motion to quash the search warrant and to suppress the evidence illegally seized. It was contended, among others, that the application for search warrant was filed and the warrant was issued by the RTC of Manila, which is a court outside the territorial jurisdiction and judicial region of the courts of Angeles City and Porac, Pampanga, where the alleged crime was committed. It was also argued that the application for search warrant was not personally endorsed by the head of the NBI, as required by the new guidelines. The Supreme Court observed that the cases against petitioners involve a violation of the Dangerous Drugs Law of 1972, RA 6425. As such, the application for search warrant may be filed by the NBI in the city of Manila, and the warrant issued may be served outside of Manila pursuant to the guidelines. The court likewise held that as to the claim that the application for the warrant was defective for not having been personally endorsed by the head of the NBI, nothing in the rule prohibits the head of the NBI and of the other law enforcement agencies mentioned from delegating their ministerial duty of endorsing the application to their assistant heads. Besides, under Section 31, Chapter 6, Book 4 of the Administrative Code of 1987, an assistant head or other subordinate in every bureau may perform such duties as may be specified by their superior or head, as long as it is not inconsistent with law. What are the properties subject to a search warrant? The property subject to a search warrant is personal property, not real property. A search warrant may be issued not only for the search but also for the seizure of the following: personal property subject of the offense, personal property stolen or embezzled and other proceeds or fruits of the offense, or personal property used or intended to be used as a means of committing an offense. Section 3, Rule 126, Rules of Court. Century Chinese Medicine versus People, 709 Scrap 177, November 11, 2013. The rule is only the personal properties described in the search warrant may be seized by the authorities. In People v. Nunez, 591 Scrap 394, search warrant number 42 specifically authorized the taking of methamphetamine, hydrochloride or shabu, and paraphernalia only, by the principle of ejusdem generis. The court explained, whereas statute describes things of a particular class or kind accompanied by words of a generic character, the generic word will usually be limited to things of a similar nature with those particularly enumerated, unless there be something in the context of the statement which would repel such inference. Certainly, the lady's wallet, cash, grinder, camera, component, speakers, electric planer, jigsaw, electric tester, saws, hammer, drill, and bolo were not encompassed by the word paraphernalia, as they bear no relation to the use of manufacture of drugs. In seizing the said items, then, the police officers exercised their own discretion and determined for themselves which items in appellant's residence they believed were proceeds of the crime or means of committing the offense. This, said the court, is absolutely impermissible. In the same case, the court declared the purpose of the constitutional requirement that the articles to be seized be particularly described in the warrant is to limit the things to be taken to those and only those particularly described in the search warrant, to leave the officers of the law with no discretion regarding what articles they should seize. A search warrant is not a sweeping authority empowering a raiding party to undertake a fishing expedition to confiscate any and all kinds of evidence or articles relating to a crime. Accordingly, the objects taken which were not specified in the search warrant should be restored to appellant. People v. Nunez. Requisites for the issuance of a search warrant. The validity of a search warrant rests on the following factors. It must be issued upon probable cause. The probable cause must be determined by the judge himself and not by the applicant or any other person. In the determination of probable cause, the judge must examine under oath or affirmation the complainant and such witnesses he may produce. And the warrant issued must particularly describe the place to be searched and persons or things to be searched. People v. Tuan, 628 Scra 226. The absence of the requisites for a search warrant's validity will cause its downright nullification. Santos v. Price Gases, 538 Scra 474. In one case of a relatively recent vintage, the appeal of the conviction essentially rested on the claim that the search warrant was defective because there was no transcript of stenographic notes of the proceedings in which the issuing judge had allegedly propounded the required searching questions and answers in order to determine the existence of probable cause. The court ruled that the failure to attach to the records the dispositions of the complainant and his witnesses and/or the transcript of the judge's examination, though contrary to the rules, does not by itself nullify the warrant. The requirement to attach is merely a procedural rule and not a component of the right. Rules of procedure or statutory requirements, however salutary they may be, cannot provide new constitutional requirements. Instead, what the Constitution requires is for the judge to conduct an examination under oath or affirmation of the complainant and the witnesses he may produce, after which he determines the existence of probable cause for the issuance of the warrant. Ogayon v. People, GR 188794. Probable cause in search warrant defined. A core requisite before a warrant shall validly issue is the existence of a probable cause, meaning the existence of such facts and circumstances which would lead a reasonable, discreet, and prudent man to believe that an offense has been committed and that the objects sought in connection with the offense are in the place to be searched. Century Chinese Medicine v. People, 709 Scra 177. There is no exact test for the determination of probable cause in the issuance of search warrants. It is a matter wholly dependent on the finding of trial judges in the process of exercising their judicial function. They determine probable cause based on evidence showing that more likely than not, a crime has been committed and that it was committed by the offender. World Wide Web Corporation v. People, GR numbers 161106. January 13, 2014. One case declared in no uncertain terms that probable cause is a flexible common sense standard. It merely requires that the facts available to the officer would warrant a man of reasonable caution and belief that certain items may be contraband, or stolen property, or useful as evidence of a crime. It does not require proof that such belief be correct, or more likely than true. A practical, non-traditional probability that incriminating evidence is involved is all that is required. United Laboratories v. EC 461 Scra 574. The determination of probable cause does not call for the application of rules and standards of proof that the judgment of conviction requires after trial on the merits, as implied by the words themselves. Probable cause is concerned with probability, not absolute or even moral certainty. The prosecution need not present, at this stage, proof beyond reasonable doubt. The standards of judgment are those of a reasonable, prudent man, not the exacting calibrations of a judge after a full-blown trial. Century Chinese Medicine case. In a case, the trial court issued a search warrant, but it later retracted from its earlier finding of probable cause. Okay, it has now been 25 minutes. Let's take a quick break. And I'd like to remind that if you're not yet subscribed to my channel, to go ahead and hit that subscribe button. It's free. And let that ad placed after this to play for a while. I really appreciate it. Thanks. Because the seized items were accordingly incomplete or insufficient to charge petitioner with a criminal offense. The retraction negated the court's previous determination of probable cause. The court disagreed because in quashing the search warrant, it would appear that the trial court had raised the standard of probable cause to whether there was sufficient cause to hold petitioner for trial. In so doing, the trial court committed grave abuse of discretion. Santos versus Price cases. When a finding of probable cause for the issuance of a search warrant is made by a trial judge, the finding is accorded respect by reviewing courts. It is presumed that the judicial function has been regularly performed. Absent the showing to the contrary, a magistrate's determination of probable cause for the issuance of a search warrant is paid great deference by a reviewing court, as long as there was substantial basis for that determination. Substantial basis means that the question of the examining judge brought out such facts and circumstances that would lead a reasonable, discreet, and prudent man to believe that an offense had been committed, and the objects in connection with the offense sought to be seized are in the place sought to be searched. Aside from the requirements mandated by Section 4 of Rule 126, the rule requires the judge to comply with a specific procedure in the conduct of the examination of the complainant and the witnesses he may produce. The required procedure involves the following. The examination must be personally conducted by the judge. The examination must be in the form of searching questions and answers. The complainant and the witnesses shall be examined on those facts personally known to them. The statements must be in writing and under oath, and the sworn statements of the complainant and witnesses, together with the affidavit submitted, shall be attached to the record. The long-standing rule is that a description of the place to be searched is sufficient if the officer with a warrant can, with reasonable effort, ascertain and identify the place intended and distinguish it from other places in the community. Any designation or description that points out the place to the exclusion of all others, and on inquiry leads the officers unerringly to it, satisfies the constitutional requirement. Moreover, in the determination of whether a search warrant describes the premises to be searched with sufficient particularity, it has been held that the executing officer's prior knowledge as to the place intended in the warrant is relevant. This would seem to be especially true where the executing officer is the affiant, whose affidavit the warrant had been issued, and when he knows that the judge who issued the warrant intended the compound described in the affidavit. Yao Senior versus People, 525 Square 108. Nowhere in Section 4, Rule 126 of any other provision of the revised Rules of Criminal Procedure is it required that the search warrant must name the person who occupies the described premises. The search warrant is issued for the search of a specifically described premises only and not for the search of a person. The failure to name the owner or occupant of the property in the affidavit and search warrant does not invalidate the warrant. Where the name of the owner of the premises sought to be searched is incorrectly inserted, it is not a fatal defect if the legal description of the premises is otherwise correct, that no discretion is left to the officer making the search as to the place to be searched. Kelnan versus People, Bar 2005. A John Doe warrant, which does not name the person subject to the same, is the exception rather than the rule. Hence, in one case, a warrant was voided to the extent that it was issued against 50 John Does, none of which could be identified by the witnesses. Pangandaman versus Khazar, 159-599. The Philippine Supreme Court declares that the purpose of the rule requiring a particular description of the things to be searched is to limit the things to be seized to those described in the search warrant, and to leave the officers of the law no discretion regarding what articles they shall seize, so abuses may not be committed. Uy K-10 versus Villarreal, 42 Phil 886. The law does not require that the property to be seized should be owned by the person against whom the search warrant is directed. Ownership is no consequence. It is sufficient that the person against whom the warrant is directed has control and possession of the property sought to be seized. Yao versus People, 525, Scrab 108, 1994, bar. The search shall be made in the presence of the lawful occupant of the house, room, or any other premises, or any member of the lawful occupant's family. In the absence of the latter, the search shall be made in the presence of 2 witnesses of sufficient age and discretion residing in the same locality. The rule in this regard is clear. No search shall be made except in the presence of the persons mentioned in the rules. Section 8, Rule 126 of the Rules of Court, 2012, bar. In Panuncia versus People, the petitioner assailed the validity of the search which was allegedly conducted while she was not in the house. The petitioner alleges that since the search warrant was defective, the items seized during the search could not be used in evidence against her. The court categorically ruled that even assuming that the petitioner or any lawful occupant of the house was not present when the search was conducted, the search was done in the presence of at least 2 witnesses of sufficient age and discretion residing in the same locality. Clearly, the requirements of Section 8, Rule 126 of the Rules of Court were complied with by the police authorities who conducted the search. If the officer is refused admittance, the officer may break open any outer or inner door or window of a house or any part of the house or anything therein, provided the following requisites are complied with. The officer gives notice of his purpose and authority. He is refused admittance to the place of directed search despite the notice. And 3. The purpose of breaking is to execute the warrant or to liberate himself or any person lawfully aiding him when unlawfully detained therein. Section 7 of Rule 126 of the Rules of Court. The officer, after making a search, must forthwith deliver the property seized to the judge who issued the warrant. He must, together with the delivery of the property, also deliver to inventory of the property seized. Such inventory must be duly verified under oath. Note: a violation of the above rules shall constitute contempt of court. The judge, on the other hand, shall ascertain if the return has been made. He shall do so 10 days after issuance of the search warrant. If no return has been made, the judge shall summon the person to whom the warrant was issued and require him to explain why no return was made. If the return has been made, the judge shall ascertain whether Section 11 of Rule 126, giving of a receipt for the property seized, was complied with, and shall require that the property seized be delivered to him. The judge shall also see to it that subsection A of Section 12 of Rule 128, delivery of the property seized into inventory, has been complied with. A judge should know that his duty as a magistrate does not end when the warrant is issued. When the evidence shows that the judge who issued the search warrant did not require the officers executing the warrant to make an accurate and complete inventory of the things seized and submit the same to him, he is guilty of gross ignorance of the law. Exceptions to the search warrant requirement asked in the 1988, 1995, 1996, 1997, 2008 bar. As a general rule, the procurement of a warrant is required before a law enforcer can validly search or seize the person, house, papers, or effects of any individual. Otherwise, such search and seizure becomes unreasonable. To underscore the significance, the law attaches to the fundamental right of an individual against unreasonable searches and seizures. The Constitution clearly declares in Section 3, Number 2, Article 3, that any evidence obtained in violation of this or the preceding section shall be inadmissible for any purpose in any proceeding. It has always been recognized that the rule requiring a warrant is not, however, absolute. There are well-recognized instances where searches and seizures are allowed, even without a valid warrant, under any of the following circumstances. People v. Nuevas. Warrantless search incidental to a lawful arrest. B. Seizure of evidence in plain view. C. Search of a moving vehicle. D. Consented warrantless search. E. Customs search. F. Stop and frisk or Terry searches. G. Exigent and emergency circumstances. H. Search of vessels and aircraft. I. Inspection of buildings and other premises for the enforcement of fire, sanitary and building regulations. People v. Vasquez. In the exceptional instances where a warrant is not necessary to effect a valid search or seizure, what constitutes a reasonable or unreasonable search or seizure is purely a judicial question, determinable from the uniqueness of the circumstances involved, including the purpose of the search or seizure, the presence or absence of probable cause, the manner in which the search and seizure was made, the place of things searched, and the character of the articles procured. Valerosa v. Court of Appeals. In the incident to a lawful arrest, a person lawfully arrested may be searched without a search warrant for dangerous weapons or anything which may have been used or constitute proof in the commission of an offense. People v. Almudial, 680-306, September 5, 2012. The search incident to a lawful arrest exception is authorized by Section 13, Rule 126 of the Rules of Court, which says, a person lawfully arrested may be searched for dangerous weapons or anything which may have been used or constitute proof in the commission of an offense without a search warrant. And the purpose of allowing a warrantless search and seizure incident to a lawful arrest is to protect the arresting officer from being harmed by the person arrested, who might be armed with a concealed weapon, and to prevent the latter from destroying evidence within reach. It is therefore a reasonable exercise of the state's police power to protect law enforcers from the injury that may be inflicted on them by a person they have lawfully arrested, and to prevent evidence from being destroyed by the arrestee. It seeks to ensure the safety of the arresting officers and the integrity of the evidence under the control and within the reach of the arrestee. People v. Kalanshao, GR 203984. The application of the above rule presupposes that the person searched was previously arrested lawfully. Hence, a person illegally arrested cannot be validly searched without a warrant under this provision. For an arrest to be lawful, the arrest may either be by virtue of a warrant, lawfully procured, or by virtue of a warrantless arrest authorized under Section 5 of Rule 113 of the Rules of Court, and other applicable provisions such as Section 13 of the same rule. Consequently, where there is no lawful arrest, the drugs purportedly seized from appellant is rendered inadmissible in evidence for being the proverbial fruit of the poisonous tree. Where the confiscated shabu is the very corpus delicti of the crime charged, appellant must be acquitted and exonerated from all criminal liability. People v. Villarreal, 693 549. Stated in another way, there must be a valid search and seizure pursuant to an equally valid arrest, which must precede the search. For this purpose, the law requires that there be first a lawful arrest before a search can be made. The process cannot be reversed. Omar v. People, GR 182-534, September 2, 2015. Under the search of moving vehicles, or the CARROL doctrine, the doctrine even in the United States is that police officers must obtain a warrant to engage in a search or a seizure unless the activity justifying the search falls within one of a few specifically established. The search of a moving vehicle, however, is one of the doctrinally accepted exceptions to the constitutional mandate that no search or seizure shall be made except by virtue of a warrant issued by a judge. This exception has been earlier called the car search doctrine, often called the CARROL doctrine, as it was first enunciated in CARROL versus United States 267 U.S. 132. CARROL was a case decided during the so-called Prohibition times in the United States. The Prohibition in the United States involved a nationwide constitutional ban on the sale, production, importation, and transportation of alcoholic beverages that remained in place from 1920 to 1933. In the case, police officers knew that the petitioner and his cohorts were bootleggers, persons who engaged in the selling of liquor in violation of the law. In fact, they had previously offered to supply undercover agents with liquor. When one day the officers saw their car by chance, they stopped the car, searched it, and found 68 bottles of whiskey stashed behind the back seat. Automobiles, declared the court, unlike a store, dwelling house, or other structure, are readily mobile, and it is not practicable to secure a warrant because the vehicle can be quickly moved out of the locality or jurisdiction in which the warrant must be sought. The ruling, however, did not authorize officers to stop every car on the road on the chance that they might find contraband. To undertake a warrantless search and seizure of a car, officers had to possess probable cause. The CARROL doctrine was re-echoed by the Philippine Supreme Court, which similarly ruled that warrantless search of a moving vehicle is justified on the ground that it is not practicable to secure a warrant because the vehicle can be quickly moved out of the locality or jurisdiction in which the warrant must be sought. People v. Tuazon, 532 Scra 152. In the case of People v. Tuazon, the court sustained the warrantless search of a Gemini car because it found that the police had probable cause to effect the search of the car, driven by the respondent. A confidential informer tipped off the police that the said car was going to deliver shabu at a certain subdivision. Surveillance of the car disclosed that it was in the place where it was reported to be. The information provided by the informer turned out to be correct, as indeed, the Gemini car was spotted in the place where it was said to be bringing shabu. When the car was flagged down, they saw a gun tucked in the respondent's waist. Since he was unable to produce any document to support his right to possess the firearm, this fact all the more strengthened the police suspicion. When he stepped out of the car, the police saw on the driver's seat plastic sachets containing white powdery substance. These circumstances taken together were sufficient to establish probable cause for the warrantless search of the Gemini car and the eventful admission into evidence of the plastic packets against the respondent. In People v. La Serna, 278 Scra 561, the court held that there was probable cause in the following instances: A. Where the distinctive odor of marijuana emanated from the plastic bag carried by the accused. B. Where an informer positively identified the accused who was observed to have been acting suspiciously. C. Where the accused fled when accosted by policemen. D. Where the accused who were riding a jeepney were stopped and searched by policemen who had earlier received confidential reports that said accused would transport a large quantity of marijuana. And E. Where the moving vehicle was stopped and searched on the basis of intelligence information and clandestine reports by a deep penetration agent or spy, one who participated in the drug smuggling activities of the syndicate to which the accused belonged, that said accused were bringing prohibited drugs into the country. Search on checkpoints, and the famous case of Valmonte versus Devilla, 185 Scra 665, 668 to 669. The court declared that nowhere in its decision did it legalize all checkpoints. that is, at all times and under all circumstances. And what it declared was that the checkpoints are not illegal per se. The court went on to hold that under exceptional circumstances, as where the survival of organized government is on the balance, or where the lives and safety of the people are in grave peril, checkpoints may be allowed and installed by the government. Implicit in this proposition is that when the situation clears and such grave perils are removed, checkpoints will have absolutely no reason to remain, for as long as the vehicle is neither searched nor its occupants subjected to a body search, and the inspection of the vehicle is limited to a visual search, said routine checks cannot be regarded as violative of an individual's right against unreasonable search. Citing American jurisprudence, the court added that routine checks, when conducted in a fixed area, are even less intrusive and are permissible. Routine checkpoint stops do not intrude similarly on the motoring public. Also, automobiles, because of their mobility, may be searched without a warrant upon facts not justifying a warrantless search of a residence or office. The cases justifying warrantless searches of moving vehicles, however, always insisted that the officers conducting the search have reasonable or probable cause to believe that they will find the instrumentality of a crime or evidence pertaining to a crime before they begin their warrantless search. Valmonte versus Devilla. Therefore, searches conducted in checkpoints are valid for as long as they are warranted by exigencies of public order and are conducted in a way least intrusive to motorists. For as long as the vehicle is neither searched nor its occupants subjected to a body search, and the inspection of a vehicle is limited to a visual search, such routine checks cannot be regarded as violative of an individual's right against unreasonable searches. People versus Vinicario. Plainview Doctrine. As in the 2007, 2008, and 2012 bar. A theoretical example could illustrate the principle particularly well. For instance, a policeman flags down a car for a traffic violation. When the officer approaches the car, he sees in the front seat of the car a submachine gun and 2 hand grenades, items not normally issued to civilians. After a few inquiries and having determined the absence of a license for the items, the officer now has a reasonable ground to seize the object without a warrant. Also, assume that an officer goes to a residence to execute a warrant to search a house for particularly described stolen antique images. As the officers look around in the living room of the house, they see on a table plastic sachets containing crystalline substances which, based on their training and experience, are illegal drugs. Since the illegal drugs are in plain view, seizing them would not be an invalid warrantless seizure. Under the Plainview Doctrine, objects falling in the plain view of an officer who has the right to be in the position to have that view are subject to seizure and may be presented as evidence. The Plainview Doctrine applies when the following requisites concur. 1. The law enforcement officer in search of the evidence has a prior justification for an intrusion, or is in a position from which he can view a particular area. 2. The discovery of the evidence in plain view is inadvertent. And 3. It is immediately apparent to the officer that the item he observes may be evidence of a crime, contraband, or otherwise, subject to seizure. Abilita III versus Doria, 596-220-228. Salameda versus People, 598-537-553-544. 2012. In one case, the police authorities were in the area because that was where they caught up with the petitioner after the chase. They saw the firearms inside the vehicle when the petitioner opened the door. Since the shooting incident just took place and it was reported the petitioner was involved in the incident, it was apparent to the police officers that the firearms may be evidences of a crime. Hence, they were justified in seizing the firearms. An object is in plain view if it is plainly exposed to the sight. Where the object seized was inside a closed package, the object itself is not in plain view, and therefore cannot be seized without a warrant. However, if the package proclaims its contents, whether by its distinctive configuration, its transparency, or if its contents are obvious to an observer, then the contents are in plain view and may be seized. If the package is such that an experienced observer could infer from its appearance that it contains the prohibited article, then the article is deemed in plain view. People v. Nuevas, 516 463. The inadvertence requirement under the plain view doctrine means that the officer must not have known in advance of the location of the evidence and discovery is not anticipated. Emphatically, it was ruled that the plain view doctrine does not apply where the police officers did not just accidentally discover the evidence but actually search for it. Valeroso v. Court of Appeals, 598 41, 58-59. While the immediately apparent requirement under the plain view doctrine means that not only must the item be in plain view, its incriminating character must also be immediately apparent. Arizona v. Hicks, 480 U.S. 321. This principle has also been followed in Philippine decisions. United Laboratories v. ECIP, 461 574. That it must be immediately apparent to the officer that the items observed may be an evidence of a crime is another important element of the doctrine. This requirement means that the incriminating nature of the evidence becomes apparent if the officer, at the moment of seizure, had probable cause to connect it to a crime without the benefit of unlawful search or seizure. To be immediately apparent, the rule does not require an unduly high degree of certainty as to the incriminating character of the evidence. It requires merely that the seizure be presumptively reasonable, assuming that there is probable cause to associate the property with criminal activity, that a nexus exists between a viewed object and criminal activity. United Laboratories v. ECIP 461 574. The court significantly stressed that the plain view doctrine cannot be made to extend to a general exploratory search from one object to another until something incriminating at last emerges. The doctrine is a recognition, however, of the fact that when executing, police officers come across immediately upon incriminating evidence not covered by the warrant, they should not be required to close their eyes to it, regardless whether it is evidence of a crime they are investigating or evidence of some other crime, because it would be needless to require the police to obtain another warrant. Under the plain view doctrine, there is no legitimate expectation of privacy, and there is no search within the meaning of the Constitution. United Laboratories v. ECIP. Example: in Abenes v. Court of Appeals. It illustrates the doctrine within the context of Philippine jurisprudence. Hence, the RTC found the accused guilty beyond reasonable doubt of illegal possession of high-powered firearms and ammunition under PD 1866 and under another information for violation of the election gun ban. Accordingly, the prosecution convincingly established that the unlicensed .45 caliber pistol tucked into the right waist of the petitioner was readily visible and therefore could be seized without a search warrant under the plain view doctrine. The petitioner raised before the Supreme Court the issue of violation of his constitutional right against an unlawful search and seizure. The court, in finding against the petitioner, declared that under the plain view doctrine, objects falling in the plain view of an officer who has a right to be in the position to have that view are subject to seizure and may be presented as evidence. The law enforcement officers lawfully made an initial intrusion because of the enforcement of the gun ban and were properly in a position from which they particularly viewed the area. In the course of such lawful intrusion, the policemen came inadvertently across a piece of evidence incriminating the petitioner, where they saw the gun tucked into his waist. The gun was in plain view and discovered inadvertently when the petitioner alighted from the vehicle. In another case, the police who had just tracked down the petitioner, who were informed of the involvement of the petitioner in a shooting incident, which just happened, saw the firearms inside the said vehicle as he opened the door of his car and got off the same. The court observed that the police authorities were in the place because it was where they caught up with the petitioner who sped up in his vehicle after initially giving his agreement to go to the police headquarters to shed light on the shooting incident. They saw the firearms when the petitioner opened the door of the car. Since the shooting took place, and it was reported that the petitioner was involved, it was apparent to the authorities that the firearms may be evidence of the crime. Hence, they were justified in seizing the firearms under the Plainview Doctrine. In 1996, the accused Valerio Rosso was charged with violation of PD 1866 for illegal possession of firearms and later was convicted by the trial court. On appeal, the Court of Appeals affirmed the conviction on a petition for review. The Supreme Court affirmed the decision of the Court of Appeals. The subsequent motion for reconsideration was denied by the court with finality. Undaunted, the accused implored the court through a letter appeal to once more take a contemplative reflection and deliberation on the case, focusing on his breached constitutional rights against unreasonable search and seizure. After considering anew arguments through the letter appeal, together with the OSG's position recommending his acquittal, and that substantial rights must ultimately reign supreme over technicalities, the court was swayed to reconsider. The court found that the accused was initially arrested by virtue of a warrant of arrest allegedly for kidnapping with ransom. At that time, he was sleeping inside the boarding house of his children. He was awakened by the arresting officers who were heavily armed. They pulled him out of the room, placed him beside the faucet outside the room, and tied his hands and then put him under the care of a police officer. The other police officers remained inside the room and ransacked the locked cabinet where they found the subject firearm and ammunition. With such discovery, the accused was charged with illegal possession of firearms and ammunition. From the foregoing narration of facts, the court concluded that the arresting officers served the warrant of arrest without any resistance from the accused. They placed him immediately under control by pulling him out of the bed and bringing him out of the room with his hands tied. To be sure, the cabinet, which was locked and forcibly opened, could no longer be considered as an area within his immediate control because there was no way for him to take any weapon or to destroy any evidence that could be used against him. The arresting officers would have been justified in searching the person of the accused as well as the tables or doors in front of him for any concealed weapon that might be used against the former, but under the circumstances obtaining, there was no comparable justification to search through the desk, doors, and cabinets of the other closed or concealed areas in that room itself. The Plainview Doctrine may not be used to extend a general exploratory search from one object to another until something incriminating at last emerges. Clearly, the search made was illegal, a violation of Valeroso's right against unreasonable search and seizure. Consequently, the evidence obtained in violation of said right is inadmissible in evidence against him. Valeroso v. Court of Appeals, 598 Squa 41. Terry searches or stop and frisk. Suppose a police officer is on a routine patrol duty and he observes two people outside a variety store. Both his experience and training tell him that their acts are consistent with acts of people with criminal designs, although he has no concrete facts showing probable cause that a crime has been committed or that it is actually being committed. He knows that mere suspicion is not sufficient to make a valid arrest, but his instincts, honed by years of experience in the streets, tell him something untoward is imminent. May he briefly stop the persons, ask them questions, and engage in a protective search for a concealed weapon short of a full-scale arrest? And we're done with our 1-hour audio listening, and I will continue this topic on my next audio. And if you like the contents of my channel, make sure you subscribe. I really appreciate it. Also, play this ad after this. And if you have some comments, please drop it in the comment box below. Thanks.